Good morning, everyone. Hopefully, after that brief break, you're all back. And here, my name is Bryan Smolock. I'm coming to you from the Department of Labor and Industry here in Harrisburg, Pennsylvania. I'm the Director of the Bureau of Labor Law Compliance. It's an honor to be here. It's a pleasure to be here. And I always tell people jokingly, it's, in my opinion, pretty fun to talk about the issues that we talk about. Some people may find it a little dull, a little dry, a little boring, but I don't think so. My hope will be during this presentation, I could share with you, as the title says, Prevailing Wage, What You Need to Know. That's the hope that we always have with these presentations, to share with you all the pertinent information that will help you with your clients or help you with any questions that you have, and that we can be a future resource for you if you have things that I didn't touch upon that you wanted to speak about further. So I will begin this presentation. I don't really think from the time frame I have that there will be much time for questions or answers, but at the end of this slideshow presentation, my contact information will be there. So I'm reachable by phone, by email, fax machine, mimeograph, however you can get me. So let's begin. So as mentioned, titled Prevailing Wage, What You Need to Know. So you might be a little surprised by the slides I have at the very beginning, but I think that you'll understand they go hand in hand and they actually connect together in an interesting tapestry. Little agenda item of what we're going to discuss today. So clearly, introduction, who we are, what we are, brief overview of what we do, some other laws. And that's where I think that I really want to stress and point out that there's some other things we do that are not directly prevailing wage, but they actually tie together when it comes to child labor, when it comes to overtime, and when it comes to something called Act 72 and also Act 75. We'll talk about the meat and potatoes of the topic of this hour, prevailing wage. And then finally, I mentioned questions and answers. Again, those questions and answers may have to be offline at a different time today or tomorrow because we may not get that opportunity. But anyway, let's begin. So who are we and what are we? Well, unfortunately, this slide for me is a little bit blurry. I don't like a slideshow that has a lot of words on it. I feel that that's actually improper. However, if you all have a copy of the slideshow, you can read what we do. In essence, our department, our bureau, is a little bureau that could within the Department of Labor and Industry. Within L&I, you're talking about things like unemployment compensation or workers' compensation, plethora of things that are done with the Bureau of Workforce Development, such as apprenticeship and training or grants that go out to different businesses. Our office, the Bureau of Labor Law Compliance, is comprised of 5 districts around the state. We have investigative staff people, we have technical people that will help with any questions and answers on legal issues. And we also investigate complaints that come in for a variety of the laws that we enforce. Those complaints could be people who don't get paid, children who are working in the industry that shouldn't be there, or on a prevailing wage job, someone perhaps not making a correct rate or not being paid at all. So it runs the gamut, and we have a number of different legislative statutes that we need to enforce. Any given day in the life of an investigator, they might pick up the phone and expect to have a call about someone not being paid. But I call them and say, get to a job site now because there's a 12-year-old on a roof on a construction project. By the way, those calls happen. I'll touch on that today too. Of the laws that we enforce, and I have a listing on the screen now in front of you, clearly prevailing wage is the topic at hand today. Minimum wage, child labor, wage payment, apprenticeship and training, Act 72 and Act 75. They all go hand in hand with prevailing wage. Seasonal farm labor, no. Medical pay, maybe. Personal file, maybe. But they tie together because on a prevailing wage job, you might have a workman on that job site who's a carpenter or an electrician, and there's a prevailing rate for them. But what if they're not receiving overtime for any time after 40 hours a week? What if they don't get paid at all at the end of that week for any work that was performed? What if it's someone who's age 16, 17 who shouldn't be on the job site? What if it's someone who's misclassified as a contractor, which is Act 72? Or what if it's someone who was never e-verified prior to work beginning That's Act 75. So when our investigators go to job sites or do any inspections of locations, we don't just look for one topic of prevailing wage. If we go to a job site for prevailing wage, we do the full course. We try to talk to workers and educate workers about most of the laws that you see on that page right now. Let's get into some details. So I want to touch upon a few different laws first before we again get into the nitty-gritty on prevailing wage, because they all go hand in hand. Wage payment and collection. All right, so in essence, what this law states, the wage payment and collection law of 1961, by the way, we're talking a law that's been around for quite a while. If you work, you need to get paid for it. It's a pretty novel concept, right? But it's in legislation, and it's an administrative law that has both criminal and or civil penalties for employers that violate. So under the wage payment and collection law, the employer must notify the worker of when payment will happen, how often, what's the rate of pay, when that rate of pay changes, has it been notified prior to the change in pay, any vacation time, fringe benefit time, any supplemental income. That's all stuff that should be notified to the worker at the time and date of hire or when changes occur. It's when workers are not notified or when workers are not paid as to when there's an issue. When there is an issue, what our investigative staff would do is we would actually have investigators who reach out to employers, try to work the scenario out, try to work that situation out. When all else fails, there's always that small percentage of cases that don't get resolutions through the administrative process. We then have to go to a court venue, whether it's a civil court or a criminal court, depending on the scope of violations, and we would argue a case like that in front of a judge. So the takeaway of wage payment and collection, the easy takeaway for all of you should be, oh, someone needs to get paid for the time worked. It needs to be the regular rate of pay as to what that was. It needs to include any supplemental benefits that are advised and promised by company policy. Pure and simple. And when our investigative staff calls an employer, we will ensure that the law was followed. And quite frankly, there's times cases come in that the employer is not in violation, right? It's not 100% across the board either way. Sometimes it's a mixture of both. We're talking about human beings that have human emotions, and sometimes they clash. And we try to work that in an administrative nature first before we go down any kind of path of court action, civil, criminal, etc. The minimum wage law. And the minimum wage law is interesting because when you hear the minimum wage law, you think, oh, minimum wage, $7.25 an hour. Sure, that's in there. The minimum wage is set by legislation. By the way, if federal law increases the minimum wage, we do too, even if Pennsylvania legislature doesn't change our law, we would coincide with any federal increase. Right now it's $7.25 an hour. Prevailing wage is not minimum wage, right? There's a prevailing minimum wage on construction projects as set by the Secretary of Labor, but this minimum wage law is for all industry. However, why it's important to you? It's important to you because also in the Minimum Wage Act would be language about overtime in Pennsylvania. Overtime being anyone who's an hourly worker, someone who should receive time and a half after 40. It's set in the act itself as 1.5, the regular rate, and that's for any non-exempt employees. Who's non-exempt? Construction workers, hourly workers, right? So it's important to remember that when work on a prevailing wage job exceeds 40 hours because it's been either maybe shop rates included or multiple job sites, or perhaps it's just work on that single prevailing wage job that week. But either way, when it goes over 40 hours, it would be time and a half on the regular rate or the rate being paid. Regular rate could very well be the prevailing wage rate, right? We'll talk about that. So but not to confuse the issue, overtime itself is not mentioned at all in the Prevailing Wage Act. Overtime is mentioned specifically in the Minimum Wage Act. So it can be a little confusing because you might have a situation where there's two different laws coinciding. Prevailing wage is one thing, but minimum wage sets out the rule that overtime needs to be paid after 40. The Child Labor Act, okay, here again, You might think this has nothing to do with prevailing wage. Didn't used to until recently. Our Bureau has unfortunately been finding a lot of kids working construction projects, and sometimes kids who are only, real story here, 12 years old. Actually happened this year in which there was a 12-year-old on a job site. It's a clear violation, 100% violation. You can't even work until the age of 14 anyway in Pennsylvania, and that's limited work. And typically on a construction job, you really shouldn't be there until 18 because we're talking dangerous activity, machinery in motion, roofs and ladders, things that kids should not be around. So I mention this because I think that it's important if you have clients out there who are in this business community struggling to find employees. We understand that's a very common thing, but be cautious and careful. When you hire a minor in Pennsylvania under the age of 18, there's specific rules that need to be adhered to, working papers, hourly breaks, limitations on times that they can work, no more than a certain number of hours per work week. But if it's construction, if it's a prevailing wage job, I'd advise you keep them away from that. They shouldn't be on a construction site. There might be some limited things that could be done, perhaps some cleanup. Perhaps a registered apprentice could have some additional training that's able to be done to get them to a job site. But quite frankly, when there's a lot of kids on a job, you're going to have injuries, and that's also something that our Bureau investigates. Quite frankly and quite candidly, I'll explain that this year in particular, our Bureau had to investigate 3 instances in which a minor actually died during work because of the work that they were doing and because of dangerous activities being performed. So, cautionary tale. Listen, I'm not trying to lecture people on how to hire, but be very cautious when it comes to children around construction. It's typically most likely going to be prohibited from happening. And we have some more laws, things that, again, relate. Act 72 we'll touch on very briefly today. That's when you are working for someone, but they classify you as a contractor. I'm sure we've all heard about that more and more in the news lately. A lot of different entities out there are having this, it's new kind of economic battle of what is a contractor and what's not. With construction, it's easy. There's an act called Act 72, and it sets out exactly point by point what a contractor is. Contractor is someone who has their own $50,000 in liability insurance, has their own business, sets their own hours, brings their own tools, has a profit and loss based off of the work that's being done, has a contract. It's when some of those things or one of those things or all of those things are lacking, you are misclassified if they don't pay you with taxes taken out. They 1099 a worker. An employer 1099s a worker, but that worker has none of those things or only some of those things. That can be an Act 72 violation. There's 3 problems there when an employer does it. Number 1, workers' comp might be involved, especially if there's an injury. Number 2, unemployment tax could be involved because proper employer taxes were not paid back into the UC office. And number 3, our bureau would have involvement because a first-time violation is $1,000 per violation. A second-time violation is $2,500 per violation. When we say per violation, that means per worker misclassified. It could be as little as 1 worker, or as we saw this year on a project, as many as 235 workers, all being treated as independent contractors, and they were not. Another law that you might have interest in, apprenticeship and training, that deals with prevailing wage because when someone is a registered apprentice with the Pennsylvania Apprenticeship and Training Office, that could qualify them to receive less pay. For example, if an apprentice is working somewhere and they are at 60%, for example, of the journeyman rate, that means the training the employer is giving me, I'm going up in percentage to the real rate of pay as to what I will eventually make throughout my 4 years or 2 years of coursework. If I'm at 60%, that means if the prevailing wage is $100, I'm only getting $60 by law, while the other workers who are not apprentices can get 100, right? So it gives the employer some abilities to lessen the pay because it's based on the training that they're getting. Finally, go to the next slide here. One more slide. Finally, the Personal File Inspection Act, believe this or not, This law has an impact as well. About 2 times this year, we received complaints from construction workers who were refused to review their personnel file by their employer. When an employer refuses to show you a file, that could be a violation. We'd administrate a process for that. One more slide on child labor. I think I covered it. Hazardous stuff, machinery in motion. Don't have kids do it. That's, if I could just reiterate that 100 times over, I would try, because we've just seen this skyrocketing amount of cases that we're seeing. All right. Here's why we're here. Prevailing wage. What is prevailing wage? Okay. So prevailing wage, in a nutshell, is state-funded construction work in some form. So when there's a state-funded job, whether it's the school district in your town putting out work that needs to be done, perhaps a new roof has to get put on, new walls, new carpeting, whatever, and it's in a public building, that's prevailing wage. But also prevailing wage would be if there's a grant that comes from a state entity and it goes to a private organization to perform work. That could be considered state-funded work as well, right? So it has changed, it's evolved, because state funding, the way the Prevailing Wage Act actually reads is, quote, any publicly funded project, unquote. Publicly funded is not just a awarding agency putting things out for bid, but these days it could be grants and whatnot like that as well. When there's a prevailing wage job, under the Act, the Secretary of Labor and Industry sets the rates. And of course, the secretary is very busy. She can't do everything. So offices do the work for the secretary. Labor law compliance is the arm of the secretary, which issues wage rates to projects, tells the employers what to pay their workers, tells the awarding agency what bid should be, what documents should be included with the bid, which would be the rates themselves, right? So that's our role in this big wheel. And when workers are not paid for the work done, our other role would be to make sure that we have employers pay them those necessary wages. That's the big picture overview. 4-prong test, though, before we get there. How do we know if something is actually prevailing wage? I mentioned publicly funded. Sure, that's a part of it. But it also has to be certain work. Construction, reconstruction, alteration, demolition, repair. Not there is maintenance. I'll get to that in a second. It needs to be done under contract, which means that kind of goes without saying, there's a contract for the work. That would mean if Labor and Industry wants to replace the walls behind me, although it says Trout right now, but the real wall behind my virtual wall, if L&I wants to replace that and has L&I employees doing it, it's not prevailing wage, because it's not being done under contract, but it's when an outside contractor gets put on that job, now it's prevailing wage. Use of public funds. There you go. That's in the Act itself. I mentioned it before. You can't escape it. There's no way to change the meaning of public funds. It's in the Act, it's publicly funded. And finally, a project that is estimated to cost more than $25,000. So if that job comes in $23,000, publicly funded, done under contract, it's construction work, it's not covered because it didn't meet the $25,000 threshold yet. By the way, how do we determine that 25,000? Materials, cost of labor combined together, what does that add up to? If it's 25 or more, we're talking prevailing wage. What is certain work? Now let's go into the details on what these things are. Construction, we mentioned it, all those things before, but we said other than maintenance. But what's maintenance? Very limited maintenance exception. Maintenance, and I will read it exactly because this comes from court decisions. The repair of existing facilities when the size, type, or extent of the facilities is not thereby changed or increased. I'll give you 2 examples. We're talking about that carpeting. Let's say the carpeting looks really okay in my office. It's been here for a little while, and I see little patches here and there that don't look right. They look a little bit altered. So we don't want to do a replacement. We'll change that little patch right here. Maybe like a 1 foot little block has to come out, get put back in, new glue gets put down. It's probably not gonna be that expensive. It's probably gonna be maintenance, right? It's when the entire carpeting gets replaced. That's when it's prevailing wage. Let's talk about one other example, which actually is a real life scenario that went to a court case. An entire room is being repainted. In this certain situation, it was an entire college dormitory being repainted. The college said, "Now this is maintenance. We're just repainting. The walls were white. We're making them yellow. We're just repainting." We took the position that it was actually reconstruction because of that court ruling where it says the scope, it wasn't the size being changed, but it was the type or extent of that facility being changed. An entire room was going to look different. We won that case. Painting is covered by prevailing wage because of that. So here again, if you're touching up here and there, oh, we forgot to paint behind your desk, let's touch that up. Okay, could be maintenance, but an entire project to change the scope of that room or that entire building, if it's painting, that's covered as well. Done under contract. Again, that seems to be pretty simple. Separate contracts, by the way, to purposely avoid prevailing wages are not they're not permissible. And when those types of things happen, we have to enforce prevailing wage many times. There's possibly some true logical demarcations we'll touch on today as well. But typically, if there's a contract being separated out to purposely avoid prevailing wage, that's a no-go. Use of public funds. Clearly, we know what that means. Awarding agencies, municipalities, school districts, authorities, PennDOT, they put things out for bid. Charter schools of the school district, they put stuff out to bid. It's prevailing wage. But again, what's new here, new in our concept of prevailing wage for a law that dates back to the 60s, entities using DC defunding, RACP money, any grants that are going out to people, that could be prevailing wage. Gets touchy when we talk about federal grants because sometimes federal money will explicitly state that it should be a Davis-Bacon project. When that happens, prevailing wages most likely are not involved on the state level. Instead, it would be Davis-Bacon rates, and you got to go to someone different than me for that presentation. And finally, the estimated cost being more than $25,000 must be a good faith estimate, right? There might be times that someone got it wrong and now it's 26 or 27,000. What's the reality there? We would say the reality is prevailing wages should be paid, right? So it's got to be good faith. And again, it has to include materials and labor combined together. Anyone that purposely splits things up to avoid prevailing wage, if caught, we have to issue rates and then enforce rates accordingly, because that's not permissible. That should not be done. Finally, on that idea of maintenance, now we talk about prevailing wage. We have different types of rates we can give out, such as if we're making a new school building, it's a building project, but we're going to pave a new parking lot. That's a highway project because we're talking outside work, right? PennDOT many times has road work. Well, many times. When doesn't road work happen in Pennsylvania, right? So when there's PennDOT projects being put out for bid, we have linked, and again, you can click this link in the PowerPoint. It goes right to our website and it gives a handy dandy listing of what is maintenance and what is not. And that's something that will be very useful to any highway contractors performing PennDOT work. I mentioned before this idea of the strong and logical demarcation. I think it's important to touch upon, especially in light of a number of grants that go out. For example, a grant might go out to make a brand new office building, and that grant recipient wants to also make a parking garage associated with it, but the grant's not paying for the parking garage. It's paying only for the office building, right? That could be right there an example of maybe a strong and logical demarcation if there's no connection between these buildings. But what makes that kind of tough for us to say there's two different projects would be if there's an elevator that connects, a heating system that does that heats both, an HVAC system that is in both connected by the one source that heats or airs both buildings. Now it's less of a demarcation because there's no logical and strong disconnection between those two different projects. The James Hans Court was a 500 James Hans Court. That's a real court building. This is what started this strong and logical demarcation. There was a specific project being done, which a building was being erected. There was a certain portion that they wanted to be prevailing wage, a certain portion that they said was not prevailing wage and just private work being done. Our department issued an opinion that was all prevailing wage, but a court struck us down, went to court and it struck it down and said, no, when there's two different independent business justifications and when there's two different scopes and true different strong and logical demarcations, we might talk about two different projects. I could always say this about this specific question. There is no one right answer that will cover all jobs that we give rates out on. We make this type of question be very specific, and we need a written request before we can issue an opinion. Pure and simple. I have some site example or some examples such as site prep versus construction, and that might be a logical demarcation. By the way, architects, lawyers, surveyors, we don't include them with the cost of jobs. So if you ever have questions about it, let us know. Penn National was a very important job. This goes back 25 years now at this point. The clock sure does tick fast. That went to court, and that stated that tax increment financing actually required prevailing wage because money touched public coffers for a very brief period of time. So a lot of different court cases have led us to where we are now. Projects not covered, maintenance projects, legitimate maintenance, right? I have work that's performed under the rehabilitation or manpower training program. There's a federal program specific for that. It's very rare that we see that. And then finally, any public work for Davis-Bacon, Walsh-Healy Acts. That's typically when it would be a federal job with no state rates involved. Who's covered by prevailing wage? Well, anyone who works in that job. Mechanics, skilled, semi-skilled, laborers, apprentices employed by contractors, subcontractors, regardless of whether their job becomes a component thereof as well. Not included would be material supply and people who perform any kind of like supervision. They're not picking a tool up, they're just supervising. By the way, common question we get. Hi, Ellen, I'm an owner operator. I am self-employed. I'm working on a prevailing wage job. What do I do? The answer back is you pay yourself the right rate for the work you did, and you fill a certified payroll out and give it to the awarding agency. There is no exemption for self-employment. You're still under the definition of the Prevailing Wage Act, a workman on the job site. Workers covered also would be surveyors, people who are surveying the ground, taking materials from the ground on the job site itself, making sure things were installed correctly. People who perform testing and balancing. For example, HVAC system goes in, we have the company comes in, hooks their computer up, tests it. Oh, things are wrong, we have to make adjustments. That's prevailing wage. That would actually be a sheet metal work typically. If it's a door lock or electrical system, it could probably be an electrician. The reason why is because they're part of the scope of that job. They're actually a contracted company coming in. They're making adjustments, they're testing and balancing. That's prevailing wage. And finally, truck driving could be considered prevailing wage. We have to be very specific on when we issue those determinations. It's very specific to the work that's happening. Workers not covered, architects, engineers, inspection, accountants not covered. Workers performing off-site work not covered. Non-working supervisors, and finally material handlers and people who just drop things off and leave, not covered. Mentioned before, apprentices, big picture, they have to be registered with the state. They can't just be, hey, we are Bryan's company and I have 15 apprentices. Oh, are you registered with the state? No, I'm not. Okay, well, good job on your program, but you have to be registered with the state to be considered allowable to pay a lesser rate to a worker. Truck drivers, mentioned before, big picture on truck drivers is when there's a dedicated location that these truck drivers are back and forth from, prevailing wage. Sometimes they're not covered if it's a non-dedicated site or non-dedicated dump pit, etc. Any questions on truck driving, send them my way. Sometimes I struggle with them as well. It's very case specific. Subcontractors. Okay, so if you are hiring someone on as your employee, you put them on a certified payroll. If you consider them a subcontractor, if they're a legitimate subcontractor, truly subcontractor, they have to do their own certified payroll. Certified payroll requirements, right? Let's talk about these. They gotta be filed weekly with the awarding agency. All workers, they look like this. I have one that was sent to me today for me to look at. All workers who are on the job need to be listed on that certified payroll along with the work that they were doing, the hours of the work that they did, and how much they received for it. And there it is. That's an example of the certified payroll when blank. So when it's filled out, all of the information would be put into that certified payroll that includes the project they're on, name of the contractor, and all of the people who were on the job site for that specific week. The second page, which I don't think I have a copy of, The second page allows the employer to list out any fringe benefits that they get, vacation, dental, life insurance, disability, holiday, etc., with the rate of pay that they're giving for it. And then they have to actually sign it, notarize it at the bottom. When we issue wage rates in our bureau, any interested party has 10 days to object. Hey, LNI, you got this wrong. You gave rates to the wrong county. You gave the wrong rate altogether. They can challenge that within 10 days. And if we are wrong, we correct and modify. If we feel that we're not wrong, we don't modify. But if people still think we're wrong, they can take it to the Prevailing Wage Appeals Board. And the Appeals Board would hear cases such as, LNI issued rates to me, but I don't think this project should be covered because it's a strong and logical demarcated job, something like that. That goes to our Appeals Board. Fringe benefits on a job site. I mentioned before, fringe benefits. Here's an easy thing. They got to be for the benefit of the employee, right? Not the employer, the employee. Typically, we're talking sick time, vacation time, 401k, hospital, medical, dental, right? All those things that, yes, the employee might have a copay, sure, but the money that could be claimed as a fringe benefit credit from the employer would be what they pay in for the worker, okay? If an employer has no fringe benefit policy at all, that's okay. There's no law that you have to. It just means that if the rate of pay totals $60 an hour, but allows you to have a $20 credit for fringes, you just pay the worker $60 in pocket now, right? It means that instead of paying the rate only 40 and doing a fringe of 20, you're paying someone 60. That's permissible. As long as you get to that total rate somehow, you can do it that way. It increases your liability for overtime, however, because if you have a worker who's being paid 60 as the base rate, anything after 40 now is time and a half on 60. We have a fringe benefit credit chart, which is very difficult to read. It calculates out how an employer can actually come up with the dollar amount of each fringe benefit. Simple thing. If I pay $6,000 a year in for Bryan's insurance, I divide that by 1,920 hours and it comes to $3.13. That means for a fringe benefit, I can take away $3.13 because I paid that in for Bryan. That could be counted as a fringe benefit. And I just go down the line, that same calculation. Or if you're really an adventurous employer, you can do the actual dollar amount as well and not do the calculation. We allow for both, but we offer up this 1920 divider, we call it, as a way to have an employer easily calculate what the fringe benefit should be. Mentioned before overtime on PW, just mention it one last time. Yes, anything on prevailing wage, there's no exemptions from overtime. If you're on a prevailing wage job, time and a half after 40 still exists and is on the rate of pay that you get. So as I mentioned before, if you have no fringe benefits at all and you have to pay someone that total rate of 60, let's say, overtime would be time and a half on 60. Skimming through because I think I may have only like 2 or 3 minutes left. I think I talked too much about child labor, perhaps. I was too passionate in the beginning. Anyway, the complaint process, when people don't get paid, they file claims with us. We investigate, we resolve it through a number of different things. Typically, prevailing wage will trigger a larger audit. We do education to the contractor. We try to get them to come into compliance. It's when things are really bad or when an employer does something really wrong that we can consider that, quote, intentional violation. If we allege an intentional violation occurred, that means we're going for a debarment, and we're saying that that contractor should not bid on any state-funded work for the next 3 years. And if we win, that means they're put onto a debarment list if they don't get state contracts for 3 years. We give out free posters and everything. And I put this slide in here because I guarantee you, some of your clients had said they're getting stuff in the mail to buy posters. They don't have to. If they want to, more power to them. But they don't have to. We give them all out for free. We have an email address, which is a resource account address you can always send any questions to. We have a main office in Harrisburg. That's the building. We have 4 other district offices around the state. Addresses and phone numbers are included with a little handy dandy picture in case you're not sure where you are if you're going there. Again, it's my trust that you'll have this PowerPoint. You'll be able to see this information close up. And right at 8:55, I am able to say thank you. I'm able to say if you have any further questions, any further concerns about prevailing wage or anything else touched upon today, we're here for that. And I appreciate the fact I'm here. I wish you all a very happy holiday season. Have a wonderful day, everyone. Thank you.